Good morning, everyone. This is Clint Coons here. I want to welcome you for another session of my office hours. In case you do not remember, if you haven't been on this call before, the way it works is that if you have any questions, I would like you to raise your hand. So often the pane of the GoToWebinar, there's a place for you to raise your hand. And you raise your hand up, what I'll do is I will unmute you, and then I'll allow you to ask your question. I'll call you out by name. So with that, let's start off by taking if anybody has a question, go ahead and raise your hand, and I will then, like I said, unmute you, and we can go from there. All right. So the first question that I have is from Dan. Dan, let me give you a second here to unmute you. Dan, you there? How you doing?
Good. Good. How you doing, Clint?
I'm doing well, thank you.
Good. I recently saw something on the internet, like an email from, I think it was from Casey Research or one of these companies I listen to, and they say that you have till April to get an additional $6,000 for Social Security. Is there anything truth to that, or is that something just I don't know what that means? Have you heard anything like that?
I have not heard anything like that, but I do know that they recently made some changes to Social Security that has to do with the start and stop method, where
Right.
people were able to apply, and that may be what they're referring to there.
Okay.
That there may be a small window of opportunity before the law goes into effect that will henceforth prevent any of those changes. So you may want to look into it to see if it's an opportunity for you. Greg Boots, who's a partner in our office, did a few webinars on that particular subject, and if you go to our website and you log in, you look for the past webinar recordings, you might be able to find additional information there.
And again, that was Greg Boots.
Greg Boots, that's correct.
All right, I'll check that out.
All right, Dan. Anything else?
Thank you. No, that's good for so far.
All right, take care.
Thank you.
All right, Rick.
Morning, Clint.
Hey, how's it going?
Good. I'd like to refer back to a blog, one of your blogs, and a question was asked: do I set up the land trust in my state of residence or the state of the properties? And your reply was, you can set the land trust and the LLC up in the same state, or you can opt to have them in different states. The land trust is a grantor trust, and unless you are setting up the trust in the state that recognizes land trust by statute, it does not matter which state you choose to govern your trust. Can you explain that last part? I don't know the reasoning regarding the fact that if the state does have a statute for land trust, that it matters.
Well, when it comes to the land trust, you could really set it up anywhere. It really doesn't matter all that much. When I set them up when I said if it has one by statute, you would adopt it by statute. Is that what you're referring to, like say Florida?
Yeah,
or
Florida,
Hawaii?
Virginia. Yeah.
Yeah. So in those particular cases, certain states that have adopted a land trust by statute, they require that you include specific language in their trust. So what we'll want to do is, let's assume that was the Florida property, and we're putting together a Florida trust, and I'm going to draft the trust per Florida law. But if it's not, let's assume it's California, then there isn't any specific language that is required in order to create the trust, and what we have to look to then is case law to determine what is valid in order for that land trust to be recognized in that state. And what's important here is that some people tend to adopt what is referred to as the Illinois-style land trust, which is a unique trust in that it was the first state to abolish the statute of uses, which was a common law that prohibited, well, it didn't prohibit somebody, it's just that if you created a trust and that you did not give the trustee any meaningful power over the assets, that they were there in name for title purposes only, the trustee, then the trust failed and the property reverted back to the grantor. So many states still follow the statute of uses and require that if you create a trust and if you want this state to recognize it as a valid trust, you have to imbue the trustee with some power over the assets. And so our trust, for instance, it gives the trustee the right to collect rents. You can make minor decisions about the property. All the major decisions, though, are still vested with the beneficiary, such as the power of sale, the power of encumbrance. So that's what I'm referring to when I talk about using the right type of trust for your particular state. Does that make sense?
It does, but maybe I didn't ask the question specifically. But so the fact that a state does have a land trust statute, does that statute prohibit having out-of-state properties using a state statute land trust? In other words, if I've Wisconsin real estate, does the Florida statute state that nope, you can only use Florida land trust for Florida properties?
Well, if you set up, no, it only have to do with Florida real estate. If you own real estate in Florida, can you see my screen?
Yes, sir.
I drew a little bar. All right, so this would be a Florida land trust because that's where the property is located.
No, let's say the property would be in a state other than Florida.
All right, so let's say it's Wisconsin.
But I want to use okay.
So if it's a Wisconsin, not LLC, if it's a Wisconsin property, then I would create a standard land trust, and I would put that property into it. I would not incorporate the Florida provisions into it, because if that trust is challenged, such as a claim is brought by an outside creditor against a trust, then the Wisconsin court is going to interpret that trust. And so I think it would be best to not include the Florida provisions, although you could. You could include them, because what the court should do, and I say should, and doesn't mean that they will, they should look to Florida law to determine how that trust is governed. But the problem in that analysis is that most likely the court will assume that when analyzing the trust, you will only apply Florida law when you're dealing with situations where there's a conflict between the beneficiaries and themselves, or the conflict between the beneficiary and the trustee. So only the internal matters would Florida law apply. But from an external standpoint, when you're dealing with a tenant who has a particular issue with the property, then they will apply Wisconsin law. And then if that trust, as it's drafted, does not comport with Wisconsin law, then you run the risk that it's invalidated.
Okay, and what's the worst case then, Clint? So let's say it is invalidated, and I have an LLC being the beneficiary.
That's right.
How am I?
Chicken and egg.
What's that?
I understand what you're saying. So what happens then? Does the property then be assumed to be held by the LLC, or is it assumed to be held by you?
So if it goes to the LLC, right, then I have protection, right?
Correct.
So how would I be?
No harm, no foul, is what you're saying?
Yeah.
Because someone could argue this, that if the trust is not recognized as the way it's drafted under Wisconsin law, for whatever reason, then title never truly vested in the trustee of the trust. Therefore, title remains in your personal name if you were the one who is considered the grantor. Now, that is a stretch for them to take that analysis and apply it to the trust, but it's always a risk. That's why I would just choose to leave out the specific Florida statutes out of my trust that's going to hold Wisconsin property.
And as you alluded to earlier, there's a statute of uses, and Wisconsin is probably the worst because there's they require more duties than just collecting rents, and I'm using third-party property managers, Clint. So even if I was to be the trustee, I'm not actively involved because I'm not collecting rents. And then there was some discussion you probably read about, well, if you pay the real estate taxes, that qualifies, but then if I send money to the property manager to pay the real estate taxes. That doesn't qualify. So I mean, I'm really up a quant.
Here's why. You're actually doing more than you think. Because in order for that property manager to engage on, let's say, repairs on the property, who do they contact?
Right.
They contact the trustee. So the trustee is the person that's authorizing that individual to make those repairs. Number two, that property manager that's managing the real estate, you as the trustee engage them to perform that service. So you're actively managing it. You're just managing it through third-party individuals.
But don't I have conflict of merger then, Clint, if I'm the trustee as well as a beneficiary, or my LLC is a beneficiary, or is the fact that...
That's a different provision. Merger kicks in when you have the trustee and the beneficiary. They're the same party. So if I set up a trust and there's an individual here, there's an individual here, so this is the grantor, this is the trustee, and this is the beneficiary. And you'll notice they're all the same people. Then you run the risk of merger when you've created a trust in that manner. So what we will typically do is change the trustee. So let's assume you're married. Then I'm going to recommend that you have your wife as the trustee for purposes of recording, and then you're the beneficiary. Or
my LLC.
Or your LLC, or you would have the husband and wife down here as the beneficiaries and the husband as the trustee. So you see here, there's a difference. There's 2, 1, 1. So that solves it.
Okay.
Now when we create the trust, I serve as a trustee most of the time for our clients, so it's not even an issue when we put it in. This is typically me.
Let me throw in the other glitch. Wisconsin, the community property state. So how would that would the separation be on the trustee who was my wife or myself? Would that be recognized, or would they say no, it's community property state, it's the same person?
Community property state is only applies to the determination of property rights vis-a-vis the marital community. It doesn't make you the same person. If that were the case, then if you committed murder, then your wife would also be charged with murder.
Okay. Got it. All right, sir. Appreciate your help.
Good questions.
Thank you.
I like it. You bet. Okay. Any other questions? If you have a question, I see there's quite a few people on here. Just got to raise your hand and ask your question, and I will answer that. All right. Here we go. Hey, Brad, it's Clint Coons. What can I do for you?
Hey, Clint. Quick question. We have a C corporation that does consulting project management work in the real estate industry. Part of our compensation sometimes can be an equity position in the deals that we consult on. I'd rather hold that equity in a different entity. What's the best way to transfer or assign that? In other words, I don't want to hold it in the C Corp. I want to take that equity, that piece of the compensation, and assign it over to an LLC. What's the best way to do that?
Okay, well, couple of ways to set that up. So when you're entering into this deal, are you a gap funder or hard money lender?
It could be as a funding entity. It could be as a project manager. It could just be as a consultant doing deal analysis and evaluation and stuff. It could take any number of forms, and the compensation just, and at some instances, may include that equity piece.
Okay. Well, then when I'm writing up the agreement with the other party, that equity piece, the problem you're going to run into in your situation is that if that equity piece is for the performance of services, then if you're audited, the argument is going to be that the equity is income to the entity that is contracted to perform the services. So if you're going to oversee a project and you get an equity kicker plus a fee, then that would have to run to your corporation. Now you could assign that equity to an LLC, but in order to do that, you'd want to make sure that the corporation that's making the assignment, well, I don't even think I'd want to run it through the corporation because that could still be considered a taxable event because they would the argument would be made that when you move that asset out, that collateral assignment of the equity out to the limited liability company, that it was an appreciated asset because you have no basis in it. Therefore, it's taxable to the entity itself at the time of the assignment, and the entity should recognize that as income. So it's kind of sticky with that one. You may be better served to reverse the transaction. Run the transaction through an LLC and then pay a management fee to the corporation for the management part of the contract.
Okay. Because
Does that make sense?
No, that does make sense because that's how it's set up now. The LLC is set up essentially as a, lack of a better term, layman's term, a holding company to hold, and it is managed by the C Corp. The C Corporation is the manager of that LLC.
Okay, perfect. And then you run it so the equity stays down here in the LLC, and then the corporation charges a management fee to the LLC for the services that it's performing.
Okay, so in those instances where we're going to get an equity piece, that transaction has to be the LLC is performing the service, correct?
Correct. I would structure it so that the LLC is the one collecting that back, is performing the service. Or you might be able to structure the agreement this way, if they'll allow it. Structure it so that you could say that the service portion of this agreement is to be performed by the corporation and the equities be taken by the LLC. It's still going to put you in the same boat because if you're audited, they're going to argue that that is still compensation for the performance of the services, and that's how it was generated. So I would leave it at that. Okay. I would run through the LLC.
Okay. Does it make any difference that the LLC and the C Corp have the exact same ownership?
No, it's irrelevant.
Okay. Okay. That sort of helps. But
did you happen to catch my recent blog on joint ventures and how to set those up and the options you have with joint venture agreements?
I don't believe so, no.
About a couple weeks ago, I wrote a piece dealing with joint venture agreements. I don't know if you ever enter into these or not, but it came about as one of my clients. He's a gap funder, and he was presented with a joint venture agreement to sign and wanted to know what my thoughts were on it. And what I'm seeing more and more when I look at these transactions is that people are signing joint venture agreements and not necessarily understanding that when you sign that joint venture agreement and you agree to lend the money, that it could possibly be construed as a partnership arrangement with that particular activity. And if something were to go wrong with the activity itself, then you could potentially be held liable if the plaintiff argued that the nature of the joint venture was a partnership, because some of these joint venture agreements, of course, have an equity component to them. Since there's an equity component, that would imply that you're in a partnership with this individual to see this to a successful outcome. Therefore, if you're going to do joint venture agreements, one of the things that you need to be cognizant of is you don't want to have that joint venture agreement between an entity that has a lot of assets, because if it does go south, then and somebody sues, the entity that's on that JV agreement could be held liable to the unknown creditors. That's why I often find that the best way to structure those, of course, is that if you're going to JV with somebody, and this is what people don't like to do because it could be expensive to set it up that way, is you create a limited liability company. Oftentimes you see this. So this is the LLC. This is party A down here. They typically have a corp, and then you have your entity over here, and then you joint venture through the LLC, and this is the one that does the project. In that manner, if anything were to go wrong, it's the LLC that takes the hit and not the individual joint ventures, which would be Corp A and Corp B.
Right.
My preference is actually to utilize a participating mortgage note. Are you familiar with that term?
Not really, no.
Okay, so a participating mortgage is a transaction where if Corp A came to me and said, hey, I want you to loan on this project up here, what I will agree to do then is loan the money, but I'm not going to enter into a joint venture agreement. Instead, I'm going to structure the transaction so that when I loan you the money, I take back let's say a second deed of trust on the property, and that second deed of trust is for interest, plus I get out of their equity. Sometimes it's referred to as an equity kicker on the back end. So
Okay.
when the property is sold in escrow, the escrow company would contact me, and it would be listed in the note that I'm entitled to, say, 6% interest plus 20% of the net sale proceeds. So that's how my equity kicker could be structured. Or you can do a convertible mortgage or convertible note where it's 6% interest, but it's convertible into 30% equity, and you have the choice of how you want to roll with that at the end of the deal.
Okay.
And in both situations, you're not, you're doing this, you're not entering into a joint venture agreement with them, so there's no, or it makes it much more difficult for someone to allege that you were partners because the nature of the transaction is in fact a loan. Two, you have protection because now you've taken back a secured position in the property. In this case, it's typically going to be a second deed of trust because the initial lender is going to be sitting in front of you.
Right.
Those different types of strategies are covered on my blog. If you just, if you go through there and search for lending and throw in some keywords. Yeah.
Good. No, I definitely will. I appreciate that. Yeah.
All right.
Okay.
Great.
All right, so
anything else?
That answers my question. It wasn't exactly the answer I wanted, but at least I know where I stand now. So.
All right, Brad. Take care.
All right. Thanks.
Enrico, are you available? You're the next one up. Enrico? All right, I'm going to switch then. Wait for Enrico to come back. Rosemary, I see your microphone. It looks like it's muted. Rosemary, you there? It appears she's not coming on. All right, if anybody else had any questions, go ahead and raise your hand. While I'm waiting for other questions to pop up, actually, here we go. Marie, I got you. Hello, Marie.
Hi, sorry, I had my other mute on as well. This is Greg,
Greg.
Marie's husband. Husband.
Sure.
So my question has to do with land trust and land contracts.
Okay.
In Michigan, in light of the fact that the deed does not transfer until a later date than the sale, right?
Mm-hmm.
Say 5 years later or whatever.
Correct.
At the sale and the closing, a memorandum of land contract is filed with the county. So how do you initiate a land contract in that situation? You just wait until the deed is passed at the term of the land contract, land contract?
So if I were to enter into a land contract with somebody, are you kind of wondering the basics of the transaction, why it's set up in the way you just described?
Well, I mean, no, I'm just what are the mechanics of setting up the land trust when you're using a land contract? Or does it simply wait until you execute the sale, the transfer of the deed at the end of the land contract?
Yeah, you're going to want to wait until you execute the sale at the expiration of the land contract. And my concern would be that in that situation, if you tried to transfer an interest, which you really don't hold, you transfer the beneficial rights of that land contract into a land trust. When title initially vests, if you try to vest directly into that land trust, I think you're going to have a gap in title insurance, and that's going to create issues for people.
Gap in title insurance, you mean at that time, not at this time?
Yes. No. At that time, at the very end, when title transfers.
Okay.
So I think you're going to create a title insurance problem for the individual purchaser. They're going to have a hard time getting obtaining the title policy. So I think the cleanest. Go ahead.
Okay, go ahead. I think you're going to say what I was thinking.
The cleanest route would be to close in your name, assuming you're the purchaser, and then transfer your property into the land contract. Unless you did it from the outset. Now, if you set this up at the outset that I'm buying it with a land contract, my land trust is purchasing the property in the land contract, then that would be fine. But the change in parties midstream, I think, is what creates the possibly an issue for title.
But still, how would you do that then? What you just said, when you initially do it, purchasing it into the land trust when you're using a land contract, there doesn't seem to be an opportunity at that point because there's no transfer of deed. And
no, but the party to the transaction is the land trust and the seller, rather than the individual and the seller.
But you have no. There's nothing to. So then the seller would have to be a party to that land trust? No,
the seller would be. So what you would have is your land trust that's set up. It enters into the agreement with the seller to buy the property under that land contract. What you have to consider here is that when you're selling property, the way they refer to it in law school is a bundle of sticks. When you buy the property and a deed is transferred to you, you receive the entire bundle of sticks. With a land contract, we're not giving you the entire bundle of sticks. We're giving you part of the sticks. And you don't get the entire bundle until you've completely paid off the property. So what are those sticks that we're giving you at that point in time when you enter into the land contract? The right of possession, the right to live there. So who would have the right of possession and the right of control over that property? It would be the trustee of the trust that entered into the land contract with the individual. They would be in that position. So they would then have the enforceable right when the property is paid off to bring the action against the seller if title is not conveyed. And vice versa. If seller brings a foreclosure action, because let's say we're 2 years into this land contract, then the parties to the foreclosure, of course, would be the seller and the land trust, the trustee of the land trust.
Okay.
Does that make sense?
Yeah, but at this point, it was if it's already closed, there's nothing we can do. It's the LLC owns it, not a trust.
Correct. So if the deal's already been entered into between the LLC and the seller, is that what I'm hearing?
Yes.
Then you're in a good position. You have asset protection. So no one could step into your shoes.
And as far as privacy goes, it still looks like the other guy owns it.
Correct.
Okay. Anything that should be done between now and then to prepare for that exchange at 5 years or whatever we transfer?
No, you're fine.
Okay.
Nothing to do.
So just take it as is, and then at that point, do the transfer into the trust.
That'd be correct. Yes.
On my own. Okay. And you mentioned something. I was just getting online when you mentioned something about having a wife, one of the spouses, being a trustee or someone else, so that because you can't. I assume that's because you can't be a beneficiary and a trustee. But can I, if the LLC is in my name, can I transfer it to myself as a beneficiary as long as somebody else is the trustee?
If the LLC is in your name, then the way I would structure that, do you want anonymity?
Correct.
Okay, so the way I would structure that transaction is I would use a nominee trustee to be the trustee of your trust. So what you'll have here is this is my LLC, and this is going to be my land trust over here, and it's going to own the property. Put the property in the LLC at first. So in this trust scenario here, the LLC is the beneficiary. Okay? It's also the grantor, since it is the owner of the property when you're setting up the land trust. The trustee of your trust should be a third party. So maybe you set it up with Clint as the trustee. So what occurs when this property is deeded into the land trust, title is vested in the trust name, with Clint Coons as trustee of the 732 trust. So that would be held on title. The beneficiary is that LLC. So now, if you don't want this LLC to own the trust interest, and you've created, let's assume, LLC number 2 over here, then what you'll do is you'll assign the land trust out to yourself. So now you become the owner of the land trust, the beneficiary, and then you would transfer your beneficial interest up to LLC number 2. None of that will hit the public record. The only thing you'll see on the public record is my name.
But that doesn't have to be done. It can be the assignment can be done. I mean, I'm currently the owner. I can transfer deeds to the trustee, but make myself the beneficiary. I mean, make my LLC the beneficiary.
That is correct.
Okay.
All right. Makes sense?
So you are recording this, right?
I am.
Okay. All right.
All right, Greg.
Very good. Thank you.
You bet. Bye-bye. All right, Rick, got another question here?
Yes, sir.
Right.
Clint, what are your thoughts, Clint, on Virginia land trust using a American tribal as a trustee? Have you or Native American?
I have not come across that at all.
Okay. All right.
I mean, there was some. We were looking into tribal trusts about 4 years ago. My partner Toby Mathis had spent a couple months digging into that, because there are some unique laws with respect to asset protection with tribal trusts, but it was a patchwork framework depending on where you went with it, and we weren't sure on how it would be interpreted, so we chose not to continue with that as an asset protection tool.
Okay.
All right.
Okay. Thank you.
Good question. Yeah. All right. We'll try Rosemary if you're available. Rosemary, you might have to unmute your phone if you're hanging on there. All right. She's still not there. I'm going to lower her hand, and we'll give Enrico. Are you there? There you go,
yes,
Enrico.
can you hear me now?
All right, I can hear you. Good.
Hi, Clint. I'm an out-of-country investor, and I was wondering, I have a couple of properties now under a C Corp, and I want to expand actually the activity. Would it make sense to put every single property into a separate LLC and link them to the C Corp?
Are these properties located in the States?
Yeah, they are located in Florida.
All right, so are the properties encumbered or unencumbered?
Good question.
Do they have debt on them? Do you know? Do you pay a mortgage?
No, it's mortgage free.
They're mortgage debt free. Okay. Then in Florida, yes, you could do this. You could create some LLCs as follows. And the LLCs would all be owned by your corporation, 100%, so they're disregarded entities. Then your corporation, once this is set up, would in turn deed each of the properties to its respective LLC, like this. Now what that does for you, it separates out the liabilities. So of course, if anything were to happen with one of these LLCs, let's assume that this one's under attack right here, then that is the only property that is at risk. Now typically in a situation like this, if we were discussing how many LLCs to create, what I'm going to look at is the equity in the property. And you may want to group some. I mean, so I have some clients that will say, Clint, I want one LLC per property because I just sleep better at night when it's set up like this, so I have 5 LLCs. Other people, what we'll do is we'll look at the equity in the property and then make a determination as what is a reasonable level that you're comfortable with, and possibly then you have 2 or 3 properties in one limited liability company, and you split them up accordingly.
Okay.
But what's key here is that the asset themselves, that has to come from the corporation. You do not want to take these interests and move them out to your own name, because if you do that, then you're going to get taxed, and you're going to be taxed twice on that transfer. There was a case out of California about 1.5 years, 2 years ago, where a couple, they had a corporation, a C corporation set up. And this was a mistake that they made. So they had this property in their C corporation. Let's assume that they bought it for $400,000 and they put in $200,000 in rehab work, so they had a basis of $600,000, but it had a 1 mil fair market value. They deeded that property into their own name. And what occurred is the IRS audited the corporation, and what the couple didn't realize is that when they took that property out of the corporation, that was a taxable event. So this corporation had to recognize $400,000 in income the year the property was deeded out. After they hit the corporation, they then audited the individual, and they said, you received $1 million in compensation the day you deeded that property into your own name. You owe us taxes on $1 million in comp. So the total tax liability for this couple on this property amounted to around $600,000 and some in back penalties and interest. And that's the result of using the C corporation and taking appreciated assets out. So you have to be really careful. Does that make sense?
Yeah.
Okay.
Yeah, but you're allowed to pay a management fee out of your C corp for your personal stuff you do.
Okay, yeah, so yeah, correct. So you pay management fees, that's how you get it out.
Yeah, yeah, okay. Perfect.
All right.
Yeah.
Nice talking to you.
Thanks.
You bet.
Bye.
Bye. All right, anyone else? Well, as I'm waiting for some hands to go up, I'll just talk to you about a case. A lot of people like to invest with self-directed IRAs, and if you've been following any of my blogs, you'll know I'm not a proponent of self-directed IRAs because I think there's a number of problems that are waiting out there, especially with the IRS now looking into them. And last year the IRS stated that they are specifically going to target self-directed IRAs that hold real estate or closely held business interests. They came out and made this statement that they're going after them. But besides the component of taxation, the other issue you have with self-directed IRAs that is not really evident to most people is the issue of asset protection. From an IRA standpoint, we always look to state law to determine what protections are given to an IRA. You have states like California, for instance, that does not offer any protections to IRAs. That is, if you have an IRA and you have a $500,000 in it and you're sued individually, creditors could get that money held inside your retirement account. Whereas in Florida, that wouldn't be accessible to the creditors. But what many people, investors, do not realize is that the way an individual creditor can backdoor your IRA and get after those assets is by showing that you engage in a prohibited transaction vis-a-vis your IRA. Because the day you engage in a prohibited transaction is the day that your IRA is invalidated. And from that point on, it loses all protections that are afforded to IRA. So it just takes one transaction to blow your entire asset protection with a self-directed IRA. Now you contrast that if you rolled your self-directed IRA into a qualified retirement plan, these are plans that we set up, and they're provided with different types of protections. With qualified retirement plans, you're looking at ERISA law. And if you set up a QRP that's governed under ERISA, then you do not have those same problems associated with prohibited transactions. And notably what I mean is this. If you have a qualified retirement plan set up and you engage in a prohibited transaction, unlike a self-directed IRA where the IRA is now invalidated as of the date that you engaged in a prohibited transaction, a prohibited transaction in a qualified retirement plan does not invalidate the plan. It only makes it a taxable event for that particular transaction. And the reason I bring this up is because most people don't realize the protections a qualified retirement plan provides over a self-directed IRA. And there was a case out of California last year that was right on point with this issue. I mean, I've been talking about this for years, and the judges the judge in this particular case in California, because it actually went up on appeal, the panel there looked at it because the individual who had his qualified retirement plan set up off of an LLC, so it was a one-person plan, set up a qualified retirement plan, had several $100,000 in there. He was being sued. I think he was actually being pushed into bankruptcy. They wanted to invalidate his qualified retirement plan because he had loaned money to himself out of the qualified retirement plan and didn't document it. He bought a boat in his qualified retirement plan and allowed himself to go out and use the boat on the lake by where he lived. And he engaged in one other transaction too, that if any one of those transactions were done through a self-directed IRA, they amounted to a prohibited transaction and you invalidate the self-directed IRA as of the date you entered into it. Well, the court looked at it and they said, well, granted, he engaged in some transactions that clearly constitute prohibited transactions, but when you're dealing with qualified retirement plans, it doesn't invalidate the plan. So the assets still are protected. The issue here is for the IRS if they want to make that a taxable event, but it doesn't give the court the power to break apart the plan. Now, I've been studying qualified retirement plans for now 17 years, and I've yet to see a plan that has lost its exempt status. The only time I've read that a plan could potentially lose it if it's so egregious in nature that the individual who set it up did not intend to treat it as a qualified retirement plan. So if you're an investor and you're looking at these issues, there's definitely some benefits to having a QRP over a self-directed IRA just from an asset protection standpoint. So keep that in mind. All right, Rick, it looks like you're up again. You have another question.
Yes, Clint. It's regarding series LLCs. Is it wise, Clint, to create and use series LLCs, let's say Illinois, for properties that are in Wisconsin, and Wisconsin does not recognize or have series LLCs?
No, it's not.
Okay.
I set up series LLCs, and for those investors, I only set them up in a state where the series LLC is recognized. And so for those people who are on this call that are not familiar with a series LLC, I'll just show you what it looks like. In a traditional investing format, you may find an individual, they come to me and they have 4 properties here. And they want protection for each individual property. That is, they don't want to group them. So the standard method would be to create 4 limited liability companies for this individual. And let's just use Illinois as the example. Now that can be expensive, of course, because it's 4 LLCs that you have to create. It's 4 annual filings that have to be maintained. Now, a series LLC operates on a similar manner, but you don't have to create 4 separate LLCs in order to gain the same type of asset protection that 4 independent LLCs provide you. The concept behind the series is to create 1 limited liability company, which people refer to as a parent or a master LLC, and then you slice it up and you create these separate cells for your investments. And inside of each cell, you put a property. Now, these cells that you're creating, they are created, well, in Illinois, they're actually created via the Secretary of State, but it's a simple form that gets filed that recognizes the independent cells. You yourself create a 2-page agreement each time you put together a cell. So you're not creating an entire LLC for each cell. All you're doing is you're running, or you're basing the cell off of the parent's provision. So when you draft the parent LLC operating agreement, you put all the provisions in there. Then when you want to buy a new property, you adopt a new cell, so you fill out 2 pages, you come up with a new name, and you specify that who the owners are, who's going to manage it. Oftentimes what we do is we have all of the cells owned 100% by the parent, so they don't have to file tax returns. Everything flows right onto the parent. So from a tax standpoint, it's as if the parent owns the cell, all the cells or all the properties. But from an asset protection standpoint, it's treated similar to what we have up here. That is, if one cell is under attack, then it is only that one cell that is at risk. So this strategy with the Series LLC is a very inexpensive way to compartmentalize all of your assets. So if something goes wrong with one property, that's the only thing you stand to lose. Further, you're able to, if you like, and I'm drafting one of these right now for a client, if you want to bring in a partner. In this case, they are gap funders, and what we've done, they work some deals with their son. We have the money in here. We created a Series LLC, and the parent LLC, which is owned by the parents, they are going to own 50% of the cell, and the other 50% of the cell is owned by their son down here. So this is a case where the son puts in money, parents put in money, and then they loan on real estate out of here. And the reason why we structured it with the cells is because they're doing that joint venture agreement I talked about earlier, that traditional method of putting together a joint venture agreement. And I explained to them, when you do these deals, if you're going to continue to use that methodology, then you should create a new cell for each deal that you enter into. So this one would loan on this property here. Therefore, if something does happen, the only thing you stand to lose would be this one cell here on a potential deal. And for this individual, we're setting it up in Nevada, the cells. And Nevada, it's really simple to create cells. It's unlike Illinois, where you must register with the state for each cell. You have to file a notification with the state. Nevada, you do not have to do that. All you have to do is come up with a different name. Many times we'll just base it off the parent. So if the parent LLC was XYZ Funding, we'll call it XYZ Funding Series A, Series B, Series C, Series D. That's what gets listed on the 2-page agreement. And they asked me, of course, like most people do when they're dealing with an attorney, how much is it going to cost me every time we have to put together another cell? And the answer is nothing, because they don't need my involvement. I give them all the paperwork. They're able then to go and complete these on their own. Every time they want to do a different deal, they just fill out 2 pieces of paper, put it in their binder, and they're off and running. So the Series LLC is a great tool. If you're looking at my blog, you'll notice that there's been a natural progression there where I've written about Series LLCs over the years. And when I first started writing about this tool, it had not gained the acceptance it has today, and I was skeptical about its use. But now that we're seeing wider acceptance of its use in multiple states, I think it's a great tool if you're operating in a state that has recognized it. If you step outside of that state, there have been 2 cases that I'm aware of. One of them dealt with a Delaware LLC, where the courts have not recognized the separateness of the individual cells, and they treated it all as one common enterprise. So you have to understand that, setting these things up, there's some work on the front end, but once they're set up the right way and you understand how to run them, it's a relatively simple and inexpensive tool to provide yourself great asset protection. Good question, Rick. Anything to follow up on that?
Yes, sir. Does your crystal ball, Clint, reveal that in the near future the majority of states legislature will allow Series LLCs, or is this just not a hot topic on the hit list of legislative duties? Yeah,
I don't see it as a hot topic. One of the things states look for as a uniform act to be recognized, in which you have these so-called experts that sit down as a panel and they draft up a Uniform Limited Liability Company Act or a Uniform Series LLC Act, and then different bar associations sign off on it and they accept it, especially the American Bar Association. That then becomes the template for a legislature then to adopt their own series statute. And you also need attorneys in that state who really want it and are willing to work with the legislature to put together the statute itself, because legislatures, for the most part, they don't care about this tool. You have to get someone behind it and to go down there and lobby for it and then help craft the statute. And so I don't see that happening very often unless you're dealing with, you know, attorneys that have a lot of free time on their hands and can do it. Remember, they don't get paid for it.
Good. Of course. All right.
Yeah.
Thank you.
You bet. All right. That was Rick. I'm not seeing any other questions right now. Anybody else have anything coming up at the top of the hour? Get in one last question here before I sign off. So with that, I want to thank you all. Wish you a great rest of the week. I'll be talking to you soon. Take care, everyone. Bye-bye.